part of the deal that emerged from our negotiated transition, and which is enshrined, my Lord, in the postscript to the 1993. My Lord will recall that the postscript said that in order to pursue national reconciliation, there will be a limited conditional amnesty. But the implication being that those who were not afforded amnesty, denied amnesty, or did not apply for amnesty, that they would have to face the consequences. So that was the constitutional and agreed approach to our transition that we were meant to stick to. And my Lord, we have no choice but to stick to it. And our submission, my Lord, is that the state, post the winding up of the TRC, has betrayed the principles and values that were set out in that postscript, which spoke about, my Lord, Ubuntu and the need to cross the historic bridge from an era of oppression and inequality to an era in which tolerance and human rights would be respected, in particular human dignity. And the Lord, in not pursuing these cases, and by secretly suppressing these cases, the dignity of families such as the Haron family sitting with us today has been deeply violated, my Lord. And in that regard, my Lord, we would submit that since most of these cases can't be revived, and in this particular case, all the suspects, main suspects, have passed on, that there's been considerable harm visited upon the families, which we would submit is incalculable. And they deserve nothing less than a full, open, and independent commission of inquiry to inquire as to how justice was denied to them. Lord, we pay tribute to the Haron family members, Shamala, Shamas, Muhammad Haron, and Fatima Masud Haron, as well as their friends and comrades who never gave up the fight for truth and justice. They kept the Imam's memory alive and pushed for this inquest to be reopened. Lord, in order to assist this Honourable Court to navigate these heads, which run to close to 150 pages, we've provided certain annexes. Annex A is a detailed chronology, which runs from the birth of the Imam to 1972. Annex B is a list of witnesses in the 1971 and reopened inquests. Annex C lists the members of the security branch involved in the interrogation, as well as their accomplices, together with their dates of deaths. Annex D is a list of exhibits in the 1970 and reopened inquests. And Annex E is the index to the transcripts of both the 1970 and reopened inquests. Lord, in terms of how we intend to approach our arguments, we've divided into roughly 10 sections. We're going to start with providing the Lordship with some background to the Imam, his political activism, his arrest, detention, interrogation, and ultimate death. We will then turn to the 1970 inquest. We will look closely, my Lord, at the bias of the magistrate and prosecutor and make certain submissions to you in that regard. Thirdly, we then turn to the reopened inquest, and we provide your Lordship with an overview of the evidence led before your Lordship in November last year. Fourthly, we deal with the abuse of detainees in security detention. We'll look at this from a historical perspective. We'll also look at certain research that was conducted, and we will give your Lordship an overview of the similar facts evidence of other detainees, because we laid that evidence before your Lordship. We then turn to the medical evidence, my Lord, of the abuse of the Imam himself. And here we will focus mostly on the expert evidence of Drs. Molefe and Naidi. We then turn to the alleged fall down the staircase, and we deal with that, and we will demonstrate that the claim of a fall down the staircase was in fact fabricated. We then turn to the cover-up, and we demonstrate how the investigation itself was little more than a means to cover up what in fact happened. Lord, we then deal with the probabilities, and we make certain submissions to you on what happened on the probabilities, on a balance of probabilities, and we ask your Lordship to make certain findings in that regard. We then turn to the question of legal liability to see what kinds of crimes were committed in relation to the interrogation and death of the Imam. And we also make certain submissions to you, and we highlight certain aspects of the law for your consideration. Then penultimately, we put on the table, propose recommendations and findings for your consideration. And then finally, my Lord, we offer our conclusions. My Lord, the next section does deal with the procedural history of the reopening of this inquest, which your Lordship is familiar with. So we, in fact, going to skip that section and move to the factual background on page 10. Lord, here we deal with the life of Imam Haron, who was a family man, a religious leader, and a political activist. We will also deal with his arrest, interrogation, torture, death, and the aftermath. Much of this detail is in the detailed chronology, which we won't be referring to. But if your Lordship wishes to look at what is happening during the detention period and the days leading up to his death, that chronology goes into detail, the minutiae. Lord, the Imam was born on the 8th of February 1924 in Newlands, Cape Town. He was the youngest of 5 children. His mother died when he was 2 months old, and when his father remarried, he was entrusted in the care of his aunt Miriam. He completed his schooling in Cape Town, and afterwards he pursued Islamic studies in Mecca for 2 years. He married Kalima Sadan in March of 1915. Together the couple had 3 children. Shamila was born in December 1950. Muhammad was born in 1955. And Fatima was born in 1963. As an indication of the high regard in which the congregation of the Al-Jamla Mosque in Stegman Road held for Haron, he was appointed in 1955 as their Imam. And my Lord, he was the youngest Imam who had served at that mosque. He also founded the Claremont Muslim Youth Association in 1958. It was a progressive organization and began publishing a monthly newsletter known as the Islamic Mirror in 1959. That organization maintained close contact with activists such as Alex Laguma, Albie Sachs, Prof. Hoffenberg, and Robert Sobukwe. Haron gave Friday sermons and public lectures during the late 1950s and 1960s, in which he was critical of the apartheid regime's racial laws. My Lord, 1960 was a tumultuous year in the history of South Africa. The popular opposition to apartheid became highly visible, such as the protest marches called by the Pan-Africanist Congress against past laws in Langa and Nyanga near Cape Town. My Lord, as we are well aware, in Sharpeville, 69 protesters were gunned down by the police, many of them shot in the back. The government then declared a state of emergency, detaining some 18,000 people and passing the Unlawful Organizations Act. The African National Congress and the PAC were banned. These organizations were forced to go underground. My Lord, these political developments informed Haron's decision to get engaged politically and to work for the liberation of the majority of South Africa's people. Soon after the end of the state of emergency in August 1960, Haron served on the fundraising committee, which provided money for the legal defense of victims of the security branch. On 7 May 1961, at a meeting at the Cape Town Drill Hall, he gave an impassioned speech describing the Group Areas Act as inhumane, barbaric, and un-Islamic. He described the law as a complete negation on the fundamental principles of Islam. They are designed to cripple us educationally, politically, and economically. We cannot accept this type of enslavement. From the minbar, which is the pulpit of his mosque, he appealed to his congregation to fast for the duration of a general strike in opposition to a decision to, South Africa's decision to leave the Commonwealth and to promulgate a new republican constitution. It was during this period that the Imam discovered that police informers had been placed in his congregation. During early 1960, Haron became known to Sergeant Johannes van Wyk, a member of the notorious security branch, because of his role in these anti-apartheid organizations. Lord van Wyk was widely referred to as Spyker, and there are different theories as to why he was given this moniker. That Spyker roughly translates to nail in English. And one theory of how he picked up this nickname relates to allegations made against him of driving nails under the fingernails of anti-apartheid activists, and so the name stuck. Lord, the security branch was a notorious section of the South African police, yet not much known was about its operations. Legislation such as the Terrorism Act of 1967 granted the branch with powers to track down, detain, and torture suspects and opponents of apartheid. By 1961, my lord, Haron was in close contact with black South Africans from Langa, Gugulethu, and Nyanga, who were engaged in anti-apartheid work. He was known affectionately by the people of these townships as Imfundisi, the priest. In the early 1960s, he was delivering sermons emphasizing the concept of brotherhood in Islam, and urged Muslims to support black South Africans in their fight against the racist apartheid regime. He was closely connected to the well-known anti-apartheid activist Barney Desai, who was also very prominent amongst the coloured community of the Cape. And through the connection with Desai, he began to support the underground activities of the PAC as well as those of the ANC. He became involved with the Coloured People's Congress and raised funds for them. Along with other resistance movements, the CPC was banned by the apartheid regime in 1960. Around 1965, Haron was identified as a security risk by Major Dirk Kotze Gennis of the Cape Town Security Branch. During 1966, Haron engaged directly with PAC members when he travelled to Cairo and addressed a conference of Muslim representatives, which was attended by members of both the PAC and ANC. He became involved in a plan to recruit young men to undertake short courses of guerrilla training outside of South Africa under the auspices of leading the country to go on Hajj, that's a religious pilgrimage to Mecca. Sometime thereafter, he met with Canon John Collins of St. Paul's Cathedral in London. Collins had founded the organisation Christian Action, which also established the Defence and Aid Fund to assist victims of apartheid. And Collins channeled funds to Haron to assist those left poor and destitute through their political activities, through harassments and detentions. But before returning to South Africa, Haron was warned that he faced the risk of being targeted by the branch. He did investigate moving to Canada, but his visa was rejected. The security branch, in particular Spyker van Wyk and Gennis, began to raid Haron's home. They also raided the Stegman Road Mosque, looking for incriminating materials. His bank accounts were scrutinized. In December 1968, he visited Holland and London. And the main purpose of the trip was to make arrangements for his daughter Shamila, who wished to become a radiographer in the UK. While in London, he confided in Barney Desai that there were informers everywhere, and he was being harassed by the security branch who were trying to persuade his employers to fire him. Desai, in fact, advised him not to return to South Africa. And because Haron's passport was due to expire in March of 1969, he decided that if it was not renewed, even though that the time had come to leave South Africa. When Haron's passport expired, the authorities did not respond to his request for renewal. During May 1969, he was instructed by the security branch to appear at Caledon Police Station. We're now going to turn to his detention under Section 6 of the Terrorism Act. He was arrested by the branch on the 28th of May 1969, on the day of Milad un Nabil. That's the day of the celebration of the birth of the Prophet Muhammad. Van Wyk and Gennis arrived at the family home and took him to Caledon Police Station, where he was detained under Section 6 of the Terrorism Act.
Was this a coincidence, Council? And I'm raising these questions because remember, I am sitting today and in the country where I know and having the benefit of having set as a commissioner myself, the magistrate, that there is no way today that a person who is not legally qualified and who does not have some experience in practice can be appointed as a magistrate of the Republic. So the danger of the measuring then is to now, and that is why I'm trying to get there to say, is there something helpful then because I mustn't measure the position then as now in relation to, in all fairness to Mr. Kun, the presiding officer, and the prosecutor.
My Lord, it may well be a relevant consideration. Certainly today, of course, it would be unthinkable in the constitutional order that any person could preside over a legal proceeding and not be legally qualified. As the Lordship points out, that would not be permitted. But in those days in South Africa, as well as in many other Commonwealth countries, as you've alluded to, my Lord, police carrying out prosecutions was not uncommon. And my suspicion, my Lord, is that a person who's not legally trained, who's not taught the principles of natural justice, who does not have a concept understanding of the rule of law, may be more susceptible to pressure and to bias. Those are submissions in respect.
Yeah, because the question of at whose pressure are you sitting? Either as a prosecutor or as a presiding officer matters. The institutional independence, that's what I'm talking about. To what extent? Dealing with this question of bias. And I'm raising them because you're raising them under this clause.
Indeed, it is a legitimate concern.
You're welcome to proceed.
Thanks, Lord. Lord, I'll just finish this short section because I'm advised that we have reached. All right, Lord, may I check? Is
11:50.
Okay, thank you. Lord, I was referring to the submissions of the late Bezos SC, and he was pointing out that some of these magistrates saw it as their duty to protect organs of state, in particular the police, and that probably explains why they tended not to interrogate police versions that vigorously. Bezos also noted that apartheid inquest courts tended to minimize the evidence of the ill treatment of detainees. And official police versions, which often contradicted by forensic pathologists who had examined the bodies of detainees, magistrates tended to ignore such expert evidence and uncritically accept the versions of the police. And improbable testimony of police witnesses were invariably rubber-stamped by these magistrates.
You see, my question is informed amongst others by this because it is unfair to expect a forensic and clinical interrogation of evidential material if one doesn't have the tool, and by tools here, I mean the training, the skills, and the experience of the presiding officer. And that is why the interest in contemporaneous with the level of training, and in particular only to the extent that we can establish.
Indeed, my Lord, and it raises the interesting question as to whether there might have been some different outcomes had these apartheid era inquests took place before the Supreme Court at the time, before judges who had to be legally trained and of course legally experienced.
Yes, because even at that time, at least to sit as a judge, you had to be legally trained.
Exactly.
You're welcome.
As the court pleases. So, police versions ruled that deceased detainees were treated with care and consideration, were readily accepted by the court, notwithstanding the evidence of pre-death injuries. My Lord, I'm reminded of some of the evidence, for example, in the Timor inquest, where police officers claimed that they treated Ahmed Timor and Salim Esaf with compassion, and that they regarded them as their children. These were brazen lies, my Lord, that were accepted by the presiding officer in that matter. Lord, if I may quote from Motley J., who presided in the reopened inquest into the death of Ahmed Timor. In his judgment, he held the following: it will be remiss of this court not to address an issue on which Bezos's evidence put a spotlight. This is the impropriety role played by some in the magistracy, prosecuting authorities and medical experts in past inquest proceedings. Bezos's evidence reveals the role of some of these public officials in being complicit in exonerating members of the security branch from the crimes they committed. The 1972 inquest into the death of Timor is one such example. From the outset, it had to take a court to allow Timor's family and their lawyers access to case documents before the inquest commenced. The evidence of the 1972 inquest further demonstrates how the prosecution made no effort to obtain evidence other than that of the police and the magistrate attempting to explain away the ante-mortem injuries without any shred of evidence supporting the claim about a brawl. My Lord, it is within this context that we wish to now examine what we believe is to be the unmitigated bias of Magistrate Kun in the 1970 inquest. Magistrate Kun concluded that Haron's alleged accidental fall down a flight of stone stairs contributed to the trauma that caused his death. Now, this was his finding despite, one, evidence that Haron had a broken rib at the Costa-Congra junction, a hematoma over the lumbosacral area, clots in the deep veins of his calves, and 27 bruises of various ages and location that could not be explained by a fall down some stairs. Secondly, a demonstrated period of inability to, at a later stage of his detention, and similar fact evidence of assault and torture in security branch detention. His bias manifested in different ways. He stopped counsel for the family from asking relevant questions. He himself failed to ask pertinent questions, and he even presented scenarios to protect the security branch. And we will deal with each in turn. Starting with Kun stopping the family counsel from asking relevant questions. Throughout the testimonies of the police, Kun demonstrated a protective attitude towards them. And I wish to quote to your Lordship some passages, and these are but two examples of such protective instances. Example one. Colonel Pienaar is being questioned by the court. Mr. Pienaar, Your Worship, I do not know whether the way we obtain written statements is relevant here. I do not believe it is. So Colonel Pienaar had been asked by Coupe SC about the method and process of obtaining statements from Haron. And so the magistrate turns to Mr. Cooper. I wonder if the question, as you put it, is actually relevant, whether it would be desirable. What does it actually have to do with it? Mr. Cooper: Your Worship, the relationship between the parties, the police and the deceased who detained them, is the crux of the matter. What happened? Which statement? Why there was